Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Good morning. Welcome to the latest edition of Angeion's Leading Litigator video series. This morning it is our pleasure to have Nick Chimicles, the founder and chairman of Chimicles and Tikellis. Thank you for joining us, Nick.
Steve, thanks for being here and thanks for having me on this program.
Oh, it's our pleasure. So I want to jump right in. One of the things that I'm seeing more of, and I know you're seeing more of, is scrutiny at the settlement stage, specifically of claims made settlement, of non-cash settlements. And I wanted your take both as obviously a practicing plaintiff's attorney, but also just as to the overall structure, how it's being affected, and what we can expect in the years to come because of the increased scrutiny.
Consumer litigation, by definition, has the characteristics, Steve, of having disparate consumers all over the country, many of whom can't even be identified at the point at which the litigation is brought. Claims-made settlements have become the stalwart way of and methodology of resolving lots of those cases. And I think what's happened is that courts have become skeptical that the benefits of the settlement are truly flowing to the class as they were intended. I think what it's doing is putting a great deal of pressure on both defense counsel, who want to settle the case, and plaintiffs' counsel, who want to resolve it as well, to make sure that it passes judicial scrutiny. I think we're going to see some decisions coming down from the Ninth Circuit, where a lot of consumer litigation is brought, giving guidance as to how scrutinized these settlements are going to be, and it's going to require a retooling of how those settlements are implemented.
But isn't there something to be said for the people who should get paid, or the people who raise their hand and say I was aggrieved, and maybe there's a reason certain people aren't making claims?
Yes, and that's one of the reasons why claims-made settlements were first devised as a way of resolving class action litigation. But courts are increasingly saying if you can identify the class members, and if the theory of the case is that they were damaged at the point of sale, then the damage was incurred at the point of sale and they ought to be compensated irrespective of whether they raise their hands. Raising the hands is a way, certainly, of developing the theory that there is an aggrieved plaintiff or an aggrieved class member. But ultimately, it's what the courts are going to require. And what may have passed muster 5 years ago may no longer pass muster in the future.
Right. So I would imagine that one of the unintended consequences of that is you're actually going to, perhaps in certain instances, keep money out of the hands of plaintiffs because it becomes such an obstacle to settlement if you're just going to send out a check to everyone. Because I feel like when defense firms are doing their sort of cost to defend versus cost to settle, they're basing it on the idea that there's going to be a claims rate of 5, 7, 10%, and those are the numbers they're using. And when all of a sudden you're having judges come in and say, no, we need to distribute to everyone, and I'm not saying it's a bad idea, I'm just saying at least in the short term, I think that would be an impediment to settlement.
Well, it will be. I think undoubtedly we're going to see some settlements that would have passed muster not being brought to the court. And that means litigation either is going to result in trial, which is a totally different calculus than the kinds of analyses that defense counsel and plaintiffs counsel make, or fewer consumer cases will be brought, because the ultimate result, people will recognize, may be that it could be a good case at the outset, but it may not be settleable without going to trial. So ultimately, trial is the determiner of how those cases will get resolved. But you're quite correct that defense counsel are going to, in essence, need to provide their clients now with a recalculation of what it's going to cost to really resolve this case if a claims-made settlement is implemented, and what it's going to take to satisfy the court.
So let's talk about trial for a minute, because to me, I've known you by reputation for a long time, and one of the things that you've always sort of been synonymous with, for me, in my mind, was an attorney who goes to trial, and there aren't many class attorneys who I can say that for. So I was hoping you could share with our viewers, A, why I have that perception, and B, how that sort of affects your practice from the outset, from when you're identifying and reviewing cases through actually litigating them.
I became a trial lawyer early in my career. I started out with a defense firm, the Schneider Harrison firm in Philadelphia. I was there for more than a half dozen years. And back in that period, young lawyers had the opportunity to try cases. And I tried at least a dozen cases while I was there. I was comfortable in the courtroom. I was comfortable with judges. I was comfortable with juries. When I started my plaintiff's practice in the early 1980s, that served me very well because, as you note, there are not a lot of plaintiff's lawyers, except in the PI field, which we don't do that kind of work, that do trial work. Right. They're good litigators, but they don't really feel comfortable trying a case. So I think that puts us in a position where we can develop credibility with regard to the litigation we initiate, because by reputation, any adversary knows we're prepared to go to trial. In terms of how we proceed from the inception of a case and how the ultimate possible trial may affect our thinking, it's really something on our mind at the point we're preparing the complaint. What are the themes that we want to emphasize? What's going to appeal to a judge at the motion to dismiss stage? What's going to appeal to a jury if the case does go to trial? So we're developing those themes as we write the complaint, and then as we get through the discovery phase, we're further developing what we think will be appealing to a jury.
Can you tell us a little bit about the cases you have tried?
Sure. When I was at Schneider, I tried all sorts of cases from both the plaintiff side and the defendant side. And what's interesting is, in one case where I was the defense counsel, our opponent was Berger and Montague, which is now one of the firms with which we work quite frequently. And in fact, the trial lawyers in that firm that tried the case against our defendant client were Laddie Montague and Merrill Davidoff, both of whom I'm very friendly with 40 years hence. The trial work that I did post departure from Schneider in my current firm involved securities fraud case that we went to trial for 5 months in federal court in Chicago before Chief Judge John Grady. We had a host of defense counsel from Chicago. That case was a jury trial. Another trial that we had in 2003 was in Los Angeles Federal District Court, and that was a 6-week trial, and it resulted in a $120 million judgment. And it's, I think, the largest judgment in a securities and fiduciary duty case that went to trial in the history of the PSLRA. So we've got a track record of that kind of success in the securities field.
I want to go back, sorry to jump all around to the idea of the automatic distributions. And it's something that, frankly, philosophically, I'm a fan of, despite the fact that it creates some pragmatic problems with regard to the settlements. I was curious if you had just a gut feeling or a thought on how sending out, if we were to send out automatic distributions to a large group of people that ended up with people receiving less money than they would have had it been a claims-made settlement, how that affects people's inclination to actually negotiate those checks.
Well, it's a very practical problem. And I think, frankly, what I think may happen is there may be a more robust claims-made settlement model that will satisfy judges if you can get that percentage that you were mentioning earlier of 5 to 10% up into the 25 to 50% range. A robust stimulation of claims may be satisfactory to a court. In terms of the math, you're quite correct. You can send out $5 checks to 20 people, or you can send out two $50 checks to 2 people. Right. So If you're dealing with a zero-sum situation, that's what the ultimate effect is. Obviously, from the plaintiff side, you want to try to raise that per claim payment as high as you can to incentivize people to negotiate that check. But that's not always possible given what the defendant's position may be in the settlement negotiation.
Sure. So you raise an interesting point also. We've been hired, we've been consulted with to do claim stimulation packages separate and apart from the notice packages. And I think that you correctly identify that that's going to have a place in class action settlement and notice procedure moving forward. The question is, how vociferously are defendants going to argue against that? Because when you're doing a notice program within the context of class actions, you're very much limited by the four corners of Rule 23, what can be in the notice. And if you're going to take out a separate claim stimulation package, any notice professional worth their salt is going to tell you to use simplified messaging. It's probably going to tell you to use messaging that harps on the specific wrongs that have been alleged in the complaint. And I have seen in practice defense counsel or defendants say, "Whoa, that's a smear campaign." So how do we identify that line where we're incentivizing people to file claims, but we're not besmirching defendants?
I think it's going to be a model, a sea change in the model. And I think defense counsel and their clients are going to have to recognize that if the model is changing, then it's going to have a certain economic impact, and they should factor it into their deliberations about how to proceed with negotiations. If defendants are not willing to take whatever the risk is, the economic risk, then they'll move forward with the litigation and ultimately to trial. But it's really a matter of accepting the new reality. And if the new reality is that in order to pass muster, the courts are going to require a more rigorous claims process, then all parties are aware of that and they factor it into their negotiation.
Right. So, Nick, like you said, you're one of the few people I know who have tried multiple securities cases and have this sort of background as a trial attorney, yet plays almost exclusively in the class action bar. Do you enjoy it? What do you like about trial practice? You know, I feel like it's something people either inherently have in their bones and they enjoy doing it, or they just do not. And obviously, you belong to the former group.
I do. I enjoy trying cases, and it's not something that you'd want a regular diet of if you're trying 6-week long or 6-month long trials. My longest trial was 18 months long in the Eastern District of Pennsylvania. But the notion of going into a courtroom, meeting a jury, trying to connect with them, trying to be genuine, trying to tell a complex story in as simple terms as possible is something I enjoy doing. From my standpoint, it's the ultimate activity, professional activity for a lawyer. If I had not had the opportunity to be trained in a firm to litigate cases in trial, I probably would be like many of the plaintiffs' lawyers, not all that comfortable being in a courtroom.
Do you think that there's a direct correlation, or maybe a different way to ask it, like, do your cases inherently have more value than someone who didn't grow up in that world because defense counsel knows that you are willing to go to the mat and you are willing to have an 18-month trial if that's what it takes?
You can't do a litmus test, and we can't determine in any scientific way how the impact would play out. But ultimately, it makes me feel more comfortable.
Right.
And that's really what's important. I want to feel comfortable being prepared, if necessary, to go to trial. I don't want to feel as if I'm being pushed into a corner where I have no trial option. In every case we file, we have a trial option.
Well, Nick, this has been absolutely fantastic. I can't thank you enough for coming here and sharing your insights and telling us about your trial work and your firm and your take on where the practice is going. It's been fantastic.
Well, thank you very much, Steve. It's been very much a pleasure.